Washington had not seen a day quite like this one since the chaotic final hours of the Nixon administration. And even those who remembered that era, who had covered it from the press galleries and the courthouse steps, admitted over hushed phone calls on Tuesday evening that what unfolded in the Capitol between 9 in the morning and the stroke of midnight bore little resemblance to anything in the modern American playbook. The Patriot Defense and Security Trust Fund, a $6.2 billion mechanism that the Trump White House had spent 14 months engineering in near total secrecy, was dead before the day's final newscasts. It died not once, but 4 times. Strangled first by a federal district judge in the District of Columbia, then briefly resuscitated by emergency executive order, then cut down again by a 3-judge panel at the D.C. Circuit Court of Appeals, and finally, conclusively, put to rest by a 6-3 emergency ruling from the Supreme Court of the United States that arrived at 10:42 p.m. Eastern and immediately sent the lights on in every senior West Wing office burning well past midnight. By then, the Republican Senate caucus had already delivered its own wound, a wound that White House Chief of Staff Raymond Goss would later describe to colleagues, according to 3 people with knowledge of the conversation, as the one they never saw coming. 14 Republican senators, including 4 members of the party leadership, had signed onto a bipartisan resolution declaring the fund an unconstitutional appropriation of funds not authorized by Congress and demanding its immediate dissolution. Their names, announced at a joint press conference at 6:15 p.m. by Senator Eleanor Whitfield of Maine and Senator David Corbin of Utah, landed in the West Wing like a detonation. This is not governance. This is a private army financed on the public dime, wrapped in the flag, and aimed at every American who dared to enforce the law. Senator Eleanor Whitfield, RME, Joint Press Conference, June 6, 2026. The fund's collapse ends, at least for now, what critics had called the most audacious attempt in the post-war era, to use federal financial power as a weapon of political loyalty. Its failure is a humiliation of historic proportions for a White House that had bet enormous political capital on its passage, and it opens a gaping vulnerability in the administration's coalition at a moment when the 2026 midterm elections are already reshaping the calculus of every Republican incumbent on Capitol Hill. 6.2B fund total killed 14 Republican defectors, 6-3. SCOTUS ruling 4. Legal strikes in one-day origins. To understand the magnitude of Tuesday's defeat, one must first understand how much machinery was required to build the Patriot Defense and Security Trust Fund in the first place. This was not a policy born on a campaign trail or sketched out on the back of a legislative memo. According to documents obtained by the Sentinel and confirmed by 4 current and former administration officials, the fund was conceived in the spring of 2025 inside a working group so tightly held that not even most of the National Security Council's permanent staff were aware of its existence. The working group operated under the bureaucratic designation Task Force Resolve, a name bland enough to be meaningless to anyone who encountered it in a meeting schedule. It was chaired, at least nominally, by Deputy White House Counsel Harriet Sohn, though former officials say the real intellectual architecture came from outside the formal government structure entirely, from a network of lawyers, financiers, and political operatives whose names appear nowhere in official White House records, but whose influence over the fund's final design was, according to one senior career official who resigned in protest last November, pervasive and deeply troubling. What Task Force Resolve ultimately produced was a mechanism of unusual and deliberately layered complexity. On its face, the Patriot Defense and Security Trust Fund was presented to Congress, to the small number of members briefed on it, as a form of expanded legal protection for federal employees and contractors involved in national security activities. This framing was chosen carefully. It invoked existing precedents. It sounded, to an uninformed ear, like a modest extension of existing indemnification programs for intelligence officers. The reality was considerably different. Buried in the fund's enabling documentation, 71 pages of dense statutory language submitted to the Office of Management and Budget under a classified rider attached to the Department of Defense authorization bill, was a provision that extended eligibility not merely to current federal employees, but to any individual who had acted, at any point since January 20th, 2017, in support of lawful directives issued by the Executive Office of the President. The phrase lawful directives was defined in Appendix C of the document in a manner so expansive that legal scholars who reviewed it after the fund became public in late April described the definition as functionally limitless and constructed with the deliberate intention of capturing every act of political loyalty ever rendered to the administration. What was inside the fund? Key provisions. The $6.2 billion Patriot Defense and Security Trust Fund, as described in enabling documentation obtained by the Sentinel, would have provided legal fee coverage, civil penalty reimbursement, and salary continuation for individuals facing federal, state, or local prosecution for acts taken in support of executive directives dating back to 2017. A separate subfund of $840 million was designated for what internal documents called continuity personnel, a category that remained classified, but which multiple sources describe as referring to individuals who had taken actions to delay or obstruct the 2020 and 2024 electoral certification processes. An additional provision would have authorized the Treasury Department to indemnify any private legal entity, including law firms, that had provided services to covered individuals, shielding them from bar disciplinary proceedings related to those services. The fund was to be administered by a newly created Office of Patriot Defense, housed within the Department of Justice, but reporting directly to the White House counsel, not to the Attorney General. The fund's financing mechanism was equally audacious. Rather than seeking a direct appropriation from Congress, a process that would have required public hearings, floor votes, and the scrutiny of the Congressional Budget Office, the administration proposed to fund it through a combination of asset forfeitures, a reallocation of unspent pandemic emergency funds, and what the OMB filing described, in language that would later become the central subject of the D.C. Circuit's opinion, as discretionary reserve transfers from the Treasury's Exchange Stabilization Fund. In plain language, the administration intended to move money that had never been appropriated for this purpose without a vote of Congress into an account it would control entirely. The day that changed everything, a timeline of collapse. At 8:57 on Tuesday morning, before most of official Washington had finished its first cup of coffee, Judge Anita Carver of the United States District Court for the District of Columbia issued a 38-page preliminary injunction blocking the fund's activation pending a full hearing. Judge Carver had been nominated by President Obama in 2013 and confirmed without controversy. Her order was blunt, methodical, and left no interpretive ambiguity. The fund's financing mechanism violated the Appropriations Clause of the Constitution, its eligibility criteria violated the Appointments Clause, and its administrative structure violated the principle of separation of powers in 3 distinct and independently sufficient ways. She ordered the Treasury Department, the Department of Justice, and the Office of Management and Budget to take no further steps toward the fund's activation within 2 hours of the order's issuance. The White House's initial response was characteristic. Press Secretary Dominic Faria, reading from prepared remarks at the 9:15 briefing, called Judge Carver's order an act of judicial overreach by a rogue Obama appointee who has confused her personal politics with the law of the land. He announced that the administration would seek an immediate emergency stay from the D.C. Circuit and expressed confidence that the courts, properly constituted, will recognize the president's authority to protect those who protect America. What happened next caught even experienced Washington observers off guard. At 10:30 a.m., before the administration's emergency stay motion had been fully filed, President Trump signed an executive order declaring Judge Carver's injunction null and void under a claimed emergency power rooted in a classified interpretation of the National Emergencies Act of 1976. The executive order, numbered 14,441, directed all relevant agencies to proceed with the fund's activation as if the injunction had not been issued. The D.C. Circuit's response was swift, and by the standards of appellate procedure, almost without precedent. Within 90 minutes, a 3-judge emergency panel convened. By 12:48 p.m., it had issued a per curiam order upholding Judge Carver's injunction, explicitly rejecting the administration's emergency powers claim, and, in a passage that drew audible gasps from the lawyers reading it in real time, directing the United States Marshal Service to ensure compliance and to treat any further attempts to activate the fund as contempt of court. No executive order, however grandly titled, can dissolve a constitutional provision. The president does not possess the authority he claimed today. He has never possessed it. The suggestion that he does is a threat to the Republic. D.C. Circuit Court of Appeals, per curiam opinion, June 2, 2026, 12:48 p.m. At the White House, the midday hours were described by multiple sources as operationally chaotic. Chief of Staff Goss convened an emergency meeting that, according to people briefed on its contents, rapidly devolved into a confrontation between those counseling compliance with the courts and those, including at least 2 senior political advisors whose names sources declined to share, urging the president to press forward and dare the judiciary to enforce its order. For approximately 40 minutes, the outcome of that internal debate was genuinely uncertain. What broke the standoff was not a change of legal strategy or a softening of presidential resolve. It was the arrival, at approximately 1:45 p.m., of a message relayed through Senate Majority Leader Harrison Webb's office. 14 Republican senators were preparing to go public with their opposition. The names were attached. They were not marginal figures. They included the chairs of the Senate Judiciary and Appropriations Committees. They included a senator from a state the president had won by 22 points. They included, most devastatingly, Senator Corbin of Utah, a man who had been publicly described by the president just 8 weeks earlier as one of the greatest patriots in American history. The 14. How a coalition was built in secret. The story of the 14 Republican senators who broke with the White House on Tuesday is, at its core, a story about how long loyalty can survive when it is asked to stand against the law. For most of the senators involved, the process of arriving at their decision had been months in the making, and had been conducted with a level of operational discipline that, in retrospect, speaks to the depth of their conviction and the genuine fear among some of them of what agreeing to stay silent would mean. Senator Whitfield of Maine, the most prominent Republican voice in the coalition, had been the informal organizing force. Sources familiar with the coalition's formation describe a series of private dinners and encrypted communications that began in mid-March, shortly after the first leaked excerpts of the fund's enabling documentation appeared in a legal trade publication and drew almost no attention from the mainstream press. Whitfield, a former federal prosecutor who had spent 2 decades in the Senate building a reputation for procedural rigor and constitutional seriousness, read the excerpts and, according to a longtime aide speaking on condition of anonymity, immediately understood what she was looking at. What she was looking at, in her reading of the documents, was not merely a legally aggressive policy. It was something closer to the construction of an apparatus of impunity, a mechanism by which anyone who had committed acts of political violence, electoral interference, or institutional subversion, in the name of the president, could be retroactively insulated from any legal accountability, funded by the American taxpayer, and shielded from even the bar associations that governed the lawyers who had helped them. To Whitfield, this was not a question of policy disagreement. It was a question of whether the rule of law in the United States was a real thing or a performance. Her first conversation with Senator Corbin came in early April. Corbin, a Mormon and a former governor with a political identity built around fiscal responsibility and institutional respect, had been an improbable Trump loyalist, someone whose support the White House had worked hard to earn and worked even harder to keep. But Corbin had his own reasons for discomfort. In private, he had been receiving detailed briefings from former senior Justice Department officials who had reviewed the fund's structure and concluded, uniformly, that its continuity personnel subfund was specifically designed to cover individuals involved in efforts to overturn the 2020 election. Corbin had voted to certify that election's results. The idea that his party's president was now asking him to fund the legal defense of those who had tried to stop him from doing so was, according to people who spoke with him during this period, a source of profound personal anguish. The coalition grew carefully, one senator at a time, through a process that emphasized 3 principles: constitutional seriousness, political self-preservation, and the understanding that there was safety in numbers. By late May, Whitfield had commitments from 12 senators. 2 more were secured in the final days of May through a combination of legal memos, personal conversations, and the quiet intervention of several former Republican presidents' advisors who had concluded in their private assessments that the fund represented a line that, once crossed, could not be uncrossed. The coalition went public at 6:15 p.m. on Tuesday, standing together in a Senate conference room with a formality and gravity that struck observers as deliberately chosen. There were no dramatic gestures, no raised voices. Senator Whitfield read a 12-paragraph statement in a measured prosecutorial tone that treated the assembled press as a jury and the American public as the ultimate judge. Corbin stood beside her, stone-faced and still, his presence doing more communicative work than any speech could have accomplished. I have given this president the benefit of every reasonable doubt. I have defended this administration when I thought it was right to do so. I will not defend this. No Republican should. Senator David Corbin, RUT, press conference, June 2nd, 2026. 10:42, the moment the lights went out. The Supreme Court's involvement had been anticipated from the moment the D.C. Circuit issued its noon opinion. What had not been anticipated, not by the White House's legal team, not by the conservative legal movement's most optimistic advocates, not by the 3 dissenting justices themselves, was the margin. A 6-3 ruling, a supermajority, on an emergency application in a single day. The opinion was authored by Justice Margaret Lowe, a George W. Bush appointee who had, over the past decade, developed a jurisprudence on separation of powers that resisted easy ideological categorization. She had ruled for and against executive power claims with a consistency that frustrated both parties' partisan lawyers, and she had written in previous opinions about what she called the constitutional immune system, the set of structural safeguards that the founders had embedded in the document precisely because they had anticipated that someone, someday, would try to concentrate power in a single office. Her opinion in the fund case, issued at 10:42 p.m. and running to 44 pages, including concurrences, was a landmark. It addressed the Appropriations Clause violation, the Appointments Clause violation, and the separation of powers concerns raised by both lower courts. But it went further. In a section that legal scholars would spend weeks dissecting, Justice Lowe wrote directly about the fund's retroactive eligibility provision. its reach back to 2017, and concluded that this feature transformed what might otherwise have been a structurally improvable program into something the Constitution was specifically designed to prevent. A mechanism by which a sitting president creates after the fact a legal shelter for those who acted in his name against the interests of the constitutional order. The 3 dissenting justices, all Trump appointees, wrote separately, arguing that the majority had overstepped its emergency review authority and that the full constitutional questions should be reserved for plenary consideration. Their dissent was, by the standards of Supreme Court discourse, pointed. Justice Lowe's majority acknowledged their objections in a footnote and dismissed them in 2 sentences. At 10:44 p.m., 2 minutes after the opinion was published on the court's website, trading in the small number of financial instruments that had been structured around anticipated fund disbursements was automatically suspended by the SEC. At 10:51 p.m., the Treasury Department, without any public announcement, removed the fund's activation documentation from the Federal Register's electronic submission queue. 7 minutes later, White House Deputy Press Secretary Clara Holt released a 4-sentence statement saying only that the administration was reviewing the court's opinion and would have more to say in the coming days. There was no assertion of noncompliance. There was no declaration of intent to seek rehearing. There was, for the first time in a very long time, silence where defiance had been expected. The reckoning. What comes next for a wounded White House? The full political consequences of Tuesday's collapse will take weeks and months to become fully visible. But several things were already clear on Wednesday morning, as the Capitol woke to a changed landscape and the West Wing's overnight communications team began the grimly methodical work of sorting through what had been destroyed and what, if anything, could be salvaged. First, the immediate legal exposure created by the fund's collapse is not trivial. The fund's activation documentation, now part of the public record as an exhibit in the D.C. District Court case, contains operational details about the Continuity Personnel Subfund that multiple former federal prosecutors described on background as potentially significant in ongoing investigations. The Special Counsel's Office, whose existence has become one of the most contested political facts in American life, did not comment publicly on Tuesday's events. But 3 lawyers with knowledge of that office's current areas of focus said that the activation documentation represented a significant development. In the context of existing investigative threads, they declined to specify. Second, the Republican coalition that formed around Senator Whitfield did not dissolve when the day ended. In the hours after the Supreme Court's ruling, Whitfield and Corbyn were described by multiple sources as actively discussing what comes next, whether their coalition remains a coherent force in the Senate, what it means for the 2026 primaries, and whether the constitutional concerns that animated their opposition to the fund extend to other aspects of the administration's current agenda. Neither senator's office would confirm these conversations on the record. Neither denied them. Third, the international dimension of the day's events was not lost on America's allies or its adversaries. By mid-afternoon, the British and German foreign ministries had each issued carefully worded statements expressing confidence in American democratic institutions. By evening, the Taiwanese foreign ministry had published a brief but pointed note expressing solidarity with all those who defend constitutional governance. In Beijing, state media's initial silence on the day's events was followed, late Tuesday night, by a lengthy commentary piece in the Global Times suggesting that the administration's domestic legal troubles represented a period of historic instability in American global leadership capacity. In Moscow, a spokesperson for the presidential administration called the day's events an internal matter, a phrase that, in diplomatic translation, carries its own distinct meaning. The markets, when they opened Wednesday morning in Asia, reflected the uncertainty without fully pricing in the chaos. Treasury yields rose slightly, the dollar weakened marginally against the euro and the yen. Gold climbed. None of these movements were dramatic, but all of them pointed in the same direction, toward a world recalibrating its assessment of American institutional stability in real time. Who joins the opposition? The 14 Republican senators. The 14 Republican senators who signed onto the bipartisan resolution against the Patriot Defense Fund include 4 current committee chairs and 2 former Senate leadership figures. Their geographic spread spans Maine, Utah, Nebraska, Alaska, Kansas, Ohio, Wyoming, Indiana, Louisiana, North Carolina, Iowa, Nevada, Tennessee, and Montana, a cross-section of the Republican electoral map that makes targeted primary retaliation politically complicated. 3 of the 14 are up for re-election in 2026. All 3 issued statements indicating they intend to seek re-election and believe their constituents share their commitment to constitutional governance. All 3 face the prospect of well-funded primary challenges. None appeared on Tuesday evening to be particularly afraid of that prospect. Within the administration itself, the recriminations had begun before midnight. 3 senior officials told the Sentinel on background that the legal team responsible for the fund's structural design, The same team that had assured the president for months that the constitutional objections were manageable was finished. Whether that meant reassignment, resignation, or something more public was unclear. And what was clear was that the architects of the strategy that had just collapsed so comprehensively were not going to be the people rebuilding from the rubble. The president himself, as of this edition's deadline, had said nothing publicly. His social media accounts had been quiet since a mid-morning post attacking Judge Carver. He had not appeared in the press briefing room. He had not called members of Congress. He had not, according to two people with knowledge of his schedule, spoken directly to his chief of staff since the Supreme Court's ruling came in. What he was thinking, what he was planning, what he might do next, these questions hung over Washington like the humidity of a June night, dense and unresolved, pressing against everything and illuminating nothing. The longer view. A republic, tested at its seams. It would be tempting, in the immediate aftermath of Tuesday's events, to write a story of simple institutional vindication, of courts and constitutions doing their jobs, of a rogue executive checked by the mechanisms the founders designed for precisely this contingency. That story is not wrong. It is simply incomplete. What Tuesday also revealed is how far the effort had advanced before it was stopped. The fund was 14 months in the making. It was financed through mechanisms deliberately chosen to avoid congressional scrutiny. It was kept secret from most of the government's own national security apparatus. It was designed, in its most consequential provisions, to reach backward through nearly a decade of American political violence and electoral interference, and wrap those who had committed such acts in a protective financial cocoon, permanently, retroactively, and at public expense. The fact that it was stopped does not erase the fact that it came extraordinarily close to not being stopped. Senator Whitfield, speaking to reporters after her coalition's press conference, was asked whether she believed American democracy had been saved on Tuesday. She paused for a long moment before answering. Saved implies that it was going to be permanently lost, she said. I don't think that was the case, but I do think it was being damaged, methodically and with intent, and that the damage would have been very difficult to repair. Whether we have actually stopped the damage or merely interrupted it, that I cannot tell you. We'll have to see what tomorrow brings. What tomorrow brings, in the constitutional sense, is a set of questions that Tuesday's legal victories did not resolve. The fund is dead for now, but the legal theories that animated it, the expansive interpretation of emergency powers, the claim that the president can move appropriated funds without congressional approval, the assertion that executive loyalty is a cognizable legal category worth protecting with public money, those theories are not dead. They exist in memos. They exist in the minds of lawyers who believe them sincerely. They will return in some form, in some context, perhaps more carefully constructed, perhaps timed for a moment when the opposition is less organized or the courts are differently constituted. The Republic held on Tuesday. It held as it has held before by a narrower margin than the history books will likely record. And it held thanks to the decisions of individuals, a federal judge who wrote a clear order and held to it, a panel of appellate judges who convened within an hour of an unprecedented executive defiance, a Supreme Court majority who chose the Constitution over political comfort, and 14 senators of the president's own party who decided, in the end, that there are things that matter more than the approval of a man who once called them the greatest patriots in American history. That is a lot to ask of a republic. It is a lot for any system of laws to absorb. The weight of it was visible on every face on Capitol Hill on Tuesday night, long after the press conferences had ended and the court orders had been filed and the fund's documents had quietly vanished from the Federal Register. Washington, for all its cynicism and its theater, contains people who feel the weight of what they do. On Tuesday, that weight was heavy enough to see. The morning will bring more. It always does.